Are you worried about protecting your legal rights in an uncertain world? How do current events affect the law and you? This is Law Talk Live.
And welcome to the Law Talk Live with Chris Dysart show with co-host Kelly Jackson.
Hey there, how are you?
Oh, I'm doing pretty good. I took my kids to the pumpkin patch today, and
are you worn out?
I am worn out. It was a beautiful day, but we went through, like, there was a ghost town and there was a haunted house, and we had to walk through the fields looking for pumpkins to pick so that Daddy could injure his back and carry him.
Carrying all the pumpkins.
Yeah, but it was a lot of fun.
Yeah, I love this time of year. The one thing, what scares me? Those corn mazes.
Oh,
I'm
really?
always worried. I think of the movie Children of the Corn, first of all. Did you see that movie? Woo, scary. And I always think I'm going to get lost in one of those mazes. But no, it was a perfect day.
It was. There was a lot of bees out, though. So when you tried to drink soda, the bees were everywhere.
They were like swarming around you, I bet.
Right.
Yeah.
But on today's show, I want to talk about two different things, and they all kind of have to do with the same topic. And the same topic is having a level playing field for the average citizen versus big companies or wealthy individuals. And here's what I mean by that. There's two fundamental rights that I think American citizens have, and number one is the power of the vote, or the ability to influence the outcome of an election, because that's one of our main democratic rights. And the next right that I think is fundamental to everyone is the jury system. And what the jury system does is that puts people on an equal playing field, the average citizen versus wealthy corporations or wealthy individuals. They say that justice is blind, and justice is blind does not mean that justice can't see. It means that justice is not supposed to take into consideration who the parties are, whether you're a rich person, a famous person, or just a regular person like I am. You're all supposed to be judged the same. So there was a argument in front of the U.S. Supreme Court just this week on October the 8th, 2013, and the name of that case that was argued was McCutcheon versus Federal Trade Commission. And at issue in that case was whether or not rich people, or even I would say the super rich, can give more money directly to political campaigns and also directly to political candidates. Because right now they're limited to giving just a certain amount to certain numbers. I would say probably they can give to 9 people versus giving it to everybody in the entire election. Did you see that?
Yeah,
decision?
this could really change the way politics is right now, because it's like you were saying, the big guy up against the common man, I guess you could say.
Right.
But I guess the whole thing is that they're arguing if this is an infringement on freedom of speech, kind of thing, right?
Well, that's what the petitioner, Mr. McCutcheon, who's a wealthy contractor I think he's from Alabama, that's what he's saying, and that's what the Supreme Court has said in past cases, that in order to have your views heard by politicians, for instance, you have a right to fund their campaigns so that your views can become enacted into law. And so they basically say that there's already been cases that say people and corporations and individuals can give unlimited amounts of money to PACs and these other organizations, but not directly to individual candidates. And the idea there being, well, that's a First Amendment right to have your views heard, and that's goes back all the way to the Watergate era, when there were some laws passed when it was found out after Nixon got, impeached for the Watergate scandal. It was found out that he had taken $2 million from the
wasn't it the dairy?
Yeah, the dairy industry. That's right.
Right.
That's right.
Right. And
then he gave him special favors.
Exactly.
And
Thanks a lot, President Nixon.
Well, no. Yeah, I'm sure he's not the first politician.
He is not the first.
And I think generally people think that giving money directly to politicians is a corrupting influence, because if a politician takes your money, then he's probably going to, or people are going to probably expect something in return. So up until now, you haven't been able to give unlimited funds to as many candidates as you want. And so what this current case is going to decide is whether you can give money to every single candidate in every single election.
So the Supreme Court only hearing the case earlier this week, right?
Correct.
And what do you think? What do you think the outcome is going to be on this?
Well, I
Because
think
it's going to be kind of split between
right. The usual characters,
Right.
which is like
And what will that mean in the future for to me, we were talking about this before we went on. Candidates spend an ungodly amount of money anyway in these campaigns, and it's ridiculous. Is what I think. I mean, I was looking up President Obama and Governor Romney almost raised the same amount of money, almost $1 billion
right.
in both of their campaigns. It's just gotten out of hand.
Yeah, and the problem is that when a candidate, either Obama or a Republican candidate, takes huge amounts of money, when they get into office, those people that have given them the money come knocking on the door
Right.
and saying, remember what I did for you. Now,
Right.
what are you going to do for me? And that really has a corrupting influence, especially when a candidate has to run for office again, because like for instance, Obama in his situation. He's not going to run for office again. He's probably basically done. I guess he could run for senator or congressman, but he can't run for president again. But people like congressmen and senators that run for office again, those people that donated them all that money to get them elected, well, they want to get elected again. In order to get elected again, they've got to keep those people happy.
Right.
And a lot of those politicians take the money from, the same super rich people or corporations over and over again, and they tend to want to do things that are going to favor the super rich at the expense of everybody else.
And the man who, Sean McCutcheon, is a Republican. And
Yes. And he's not the only petitioner. The Republican National Committee
right.
also petitioned.
But you know what? I was thinking about this, and it's not just Republicans. It's both parties who have something to gain in this. And
it is both parties. Both parties are, I don't know if they're equally at fault, but they're both at fault. They both are influenced by the same thing. They both need to raise the same amount of money, like you were saying before. When Romney and Obama ran, they both were trying to raise $1 billion each, and there's only so many people that can give them the big money. I guess regular people can give small donations, but they're not going to get the same kind of
right.
access and
Right. The same kind of, I don't want to say favors, but same kind of, well, yeah.
yeah, I mean, it's access because obviously if you're somebody that gave the presidential campaign, $1 million or several $1 million, then
Right.
Somebody's going to care more about talking to you if you're a candidate than if you only gave them
Right.
$50 or something.
Exactly. It'd be interesting to hear what our listeners have to say on this too.
It would be interesting. So if anybody has any comments on that, if you could please call us at 314-969-KTRS or 888-550-5877. Again, that's 888-550-5877. All right, so, the current limit on campaign contributions directly to candidates or directly to political parties, it's $48,600 to candidates and $74,600 to party committees. And so I guess they're trying to see if people can give up to, I think, $7 million total, which is a big difference.
That's a huge difference.
Yeah, and the depressing thing is if you listen to the arguments in front of the court and you listen to what the judges were saying, and I'll just talk about what Scalia was saying. He was saying, well, $3.5 million is really not that much money. And I guess what he means by that is, it's a lot of money to me.
I know, we're all looking at each other in the studio. What?
Yeah.
That's a lot of money.
But I guess when he's saying that, the whole campaigns are like $1 billion a piece in the big scheme of things.
Right, when you look at it that way.
Yeah, and his whole position kind of is, well, there's so much money going into this anyway, and it's a First Amendment right to do this because people have a right to have their views heard, and the only way they can have their views heard is to fund these campaigns or so that their candidates can embody what they want to have done in politics. But I think that the fundamental problem with that is there's only certain people that can have their views heard under that thinking process, and that's the super rich people.
Right, and then there's the political action committees also that spent millions of dollars too.
Yeah, and that goes back to that infamous Citizens United versus FEC case. There was a passed, I think, in 2010, which opened the floodgates, and you see all these PACs that can now fund all these commercials, and it's just like,
yeah, which is something else I think is very interesting because, as many political ads as you see, it's interesting. They do all those surveys. How many people believe the ads, and how many people, how credible are those ads that they spend millions of dollars on anyway? I think they spent more than $65 million just on television ads for the campaigns, the PACs.
Right.
Yeah.
I think we have a caller.
We do?
All right, Kelly. Okay. Hi, Neil. What's your question for us today?
Yes. Well, just actually a couple of comments. And interesting you're talking about the ads. I guess I always kind of consider this issue a little bit of a stalking horse because they're not taking that money and setting it out on the highway and burning it. That money goes toward, and I'm not involved in any political activities, but my 2 points are that's some ad writer's salary, that's some cameraman's salary, that's some radio person's salary. So it's just part of the general economy. And so is it so bad, number one? And then really my bigger issue is, because I had several discussions with folks, I don't disagree that it does seem like an awful lot of money. I think you mentioned that the last presidential campaign, they raised near $1 billion. But you know what? That's only $3 a person. There's 330 million Americans. I don't mind if they spend $3. $1 billion sounds like a lot, but in the grand scheme of things, I think that the way influence gets peddled in a lot of different ways is bad. But I think to focus it just on the fact that, my gosh, isn't this $1 billion a lot? Well, no, it's not all that much. And secondly, the $1 billion is somebody's salary. So I guess I wish that was always part of that same discussion because we got big problems in our electoral system, but I don't know that the money per se is the only factor. But interesting discussion, though.
Okay. Well, thank you, Neil. And here's
thanks, Neil.
My view of that is it's not just the general overall amount of the money. It's the fact that certain people or certain corporations can give so much more money than the average person. And because they can give so much more money, it's more likely that they're going to have an undue or a huge influence on the outcome of the election. And then once the election takes place, they're going to have, a seat at the table that average citizens are not going to have. So they're more likely to have their views heard and then enacted into laws that affect everyone.
No, can't debate that. Can't debate that point. But if a block of individuals put up $5 a piece, they could overwhelm what any group of corporations could. I mean, just if the public were that against an issue, they can turn the tide. But because it's really not all that much money in the grand scheme of things. But most people don't really give a hoot. They don't care enough to put $50 or $100 to their favorite candidate. And so, when silence is approval, when you decide to abdicate your involvement, then you do suffer the consequences. And sometimes those aren't good. I'm not really disagreeing with you. Yeah. I guess I'm just disagreeing with the way, or not disagreeing, but I'm just looking at the issue from a little bit different perspective because, it's not that much money. If everybody wanted to give $20, it wouldn't matter how much a corporation or a union or a wealthy individual gave. It'd be dwarfed by what the masses could do if they wanted to get involved.
Well, I understand that position, but here's my view on that. What you're talking about requires a bunch of different people to agree on a certain issue and get together. That's different than just one man who has a lot of money having his view heard, or one company that has a lot of money having their view heard, where they really don't have to join up with anybody. They can overwhelm, hundreds or thousands or even millions of people unless they all agree, they're well organized, they all pitch in money for the exact same thing. And that's a much more difficult thing to achieve than just one person who has the money getting his own views heard. So, that's where I think the problem is that individuals that are very wealthy, super rich, for instance, or companies that are super rich, they have an unfair advantage over an individual or even several individuals.
Neil, I love your idea, though.
Well,
Hey,
Right, and
Americans, everyone pitch in $5. I think that's a great idea, and go up against corporations.
And that is kind of what happened in the last election. They've tried to do that to equal it out, but the reality is that one person with, I'll say, an extreme view can have their views, enacted into law just because they have the advantage of having all the money themselves.
Well, and again, that there's certainly inequity in the way the world works, and I guess a little bit like the idea of the keeping in mind that the money does add to the economy. The other side of that is the person who decides to spend $7 million or those figures you were using. He didn't go out and steal it, or she, or the corporation. That is part of what America is based on. Is that if I have $10,000 and I'm passionate enough about bowling rights, then I want to support the congressman that supports bowling rights, and that should be my prerogative. And if enough other people want ping pong to be the national sport, then let them get organized. But don't diminish my ability to promote bowling, just because I happen to have worked harder or whatever, or I'm a DuPont descendant and I've got piles of money. But if as long as somebody came by the money legally and ethically, then they should be able to do with it what they want. And a lot of times my group's on the poor end of the stick. But thankfully we're in a country where we can have the discussion.
No, I appreciate it. I appreciate it, Neil.
Folks in Russia wish they could be having this conversation.
No, you're right, and thanks a lot for calling in, Neil. We have to take a break now. Thank you. Okay, and we're back with Law Talk Live, and I just wanted to say a few more things about this. First, I wanted to kind of talk about just a few things that the attorneys argued in the case, and the attorney that was arguing for McCutcheon, his name was James Bopp, and he basically gave two reasons why he thought that these campaign finance limits should be eliminated. And he said that the current limits only allow you to contribute money to up to 9 candidates, and but you can contribute money to PACs, but you can't directly contribute money to political candidates or to the political parties. And I think that the problem with that argument is when you start giving money directly to political candidates, for instance, and they know you're the person giving them the money, I think there's a greater likelihood for what's called a corrupting influence, meaning you're going to feel like you owe that person for helping you get elected, and you're far more likely to look out for that person's interests or that corporation's interests. And so I think that's where the problem.
Yeah, and that's
really
human
lies.
nature. When someone does a favor for you, then you feel, or does something for you, truly in a big way, you feel the need to want to do something in return.
Right.
McCutcheon was quoted, Sean McCutcheon, the man who is going up against the Supreme Court, told the New York Times that Americans, quote, need to spend more money on politics, not less.
Well, I mean, there's a good point for that, but a lot of people don't have the money to spend.
Right.
So, all right, now I wanted to switch gears here, and when I started the show, I talked about leveling the playing field, and the two ways to level the playing field are with the ability to vote, the ability to influence politicians. That's one way to do it, and the other way is through the jury system. And I wanted to talk about the recent attacks on the jury system by what's called arbitration clauses, and I guess this is probably a little bit more of a dry topic.
This is real lawyery, isn't it?
Yeah, very, very lawyery, but it's a very important topic, so I wanted to talk about it because I think there's some misunderstanding about it. Now, almost 2 centuries ago, Thomas Jefferson said, "I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its constitution." So he considered a jury to be something that could serve as a check against governmental power. And, that happens most frequently in the case of criminal cases when the government, either the U.S. government or a state government, can charge somebody with a crime. And, it used to be that you would have to go in front of a judge that was appointed by the government or maybe he was elected, but he felt like he was part of the government, and then it would be hard to get a fair shake with that. But recently, corporations have begun putting arbitration clauses in different types of contracts, and they put arbitration clauses in nursing home contracts. They put them in checking accounts, and they put them in other areas, and they do it basically industry-wide. And the problem with an arbitration clause is arbitration is a situation where you have to go in front of an arbitrator, either one arbitrator or three arbitrators. You have to pay high costs to go in front of an arbitrator. Now, when you file a case in court to enforce your civil rights, like you say somebody injured you in some kind of accident, or you say somebody ripped you off, like a company ripped you off, like, say, a credit card company ripped you off, or somebody, cheated you, like a marketing company cheated you and misrepresented something to you, or some other company did something wrong to you and you want to sue them in court, well, that costs a certain amount of money to file the case. But often you can find attorneys that will represent you on what's called a contingency fee, and it doesn't cost you a lot of money to take them to court and have your rights enforced. But with these arbitration clauses, what you have to do is you have to go in front of an arbitrator or a panel of arbitrators, and then you have to pay the arbitrator's fee. And the arbitrator's fee, instead of not costing anything, can cost you anywhere from a couple $100 an hour to up to $1,000 an hour. So that's one problem with arbitration. Another problem with arbitration is that arbitrators tend to be somewhat biased in favor of companies. You're looking at me, Kelly. Let me ask you, are you familiar with arbitration clauses at all?
Actually, no, I'm not familiar with arbitration clauses. And it's interesting that you were saying in certain instances, are you talking nursing homes?
Yeah, nursing homes. When you sign up for a nursing home, that's the thing is most people don't realize, like when you sign documents for a checking account, or when you put your loved one in a nursing home, or when you would go into a nursing home, you sign papers, and in those papers, hidden in the language, they can be 100 pages of documents you're signing, and you're usually under stress when you're putting a loved one in a nursing home, or you may not be paying attention when you're signing up on for a checking account to what you're signing really. There'll be a clause in there that says if you have a dispute with us or you have a problem with us, you can't go to court. You have to go to an arbitration panel.
Okay.
Yeah. So it's kind of limiting where you can file a dispute. You can't just file a case in court. And
you're saying, and oftentimes it's not in their favor.
It's not
when there's some type of a dispute.
Yeah, I mean, I would say it's really never in favor of a consumer to sign an agreement that's got an arbitration clause in it. And the problem is in recent Supreme Court decisions, they have over and over again said if you sign a document and it has an arbitration clause in it, you must have agreed to that, even though most people do not know what they mean, do not even know they're there.
And don't, like you were saying, they don't read through the fine print. Many of us don't, in cases like that.
Right, and even if they did read through the fine print, unless they're an attorney or have an attorney present with them, they don't really realize that, okay, so I'm putting my loved one in a nursing home, and let's say the nursing home then sexually abuses my loved one. Certainly I'll be able to take these people to court and hold them accountable, but no, you won't be able to.
Because you signed that clause.
That's right. That's right. Now, there's certain exceptions, and there's certain ways to try to get around that stuff. But it's just the overall general idea that you're limiting your rights, taking away your rights, which is a Seventh Amendment right. You have a jury trial, which is a constitutional right. There's a statute, an arbitration statute, which the Supreme Court says kind of trumps all other rights. And so you'll end up going in front of an arbitrator, and businesses go in front of arbitrators all the time. So the advantage they have in arbitration is they generally know who the good arbitrators are, meaning who's going to rule in their favor. The fact that they bring so much business in front of the same arbitrators again and again makes the arbitrators tend to lean in their favor because they know that's where their business is coming from.
Right.
So you get that bias element. Another problem with arbitration is, let's say the nursing home, like the last guest we had on last week, the guy who wrote Nursing Home Nightmares. Let's say the nursing home has not been turning your loved when they develop pressure sores and then they get a disease like sepsis, and then they have to have surgery, and then maybe they end up even dying from sepsis. Well, as a citizen, you have to go do discovery. You have to get documents to find that out. You have to take the depositions, ask questions of the people that work there. in arbitration, your right to do that is very limited. And in fact, an arbitrator does not have power to compel depositions from those people. So that gives the unfair advantage to the party that has done something wrong.
Right, because the arbitrator would not know that kind of backstory.
Yeah,
info.
There's no way for him to know that story unless that story is revealed to him, and the only way to really reveal it is through what's called the discovery process, which you have in a case where you would have a jury trial, and those rights are severely limited. Another thing about arbitration clauses is, for instance, you may buy a product in St. Louis, Missouri, but you may have to arbitrate the case in Los Angeles, California, because that's part of the arbitration clause. Oh. And that's very expensive, and that may be more expensive than the case is worth. If, for instance, somebody only stole like $100 from you, you have no right to get that back.
Is there any way when you're, I'm just using, again, nursing home because we keep using that as an example. Right. Is there any way that you can bypass that arbitration clause when you want to, sign a contract or something with, say, for instance, a nursing home? Can you get past that and still be able to put your loved one in a nursing home?
Well, I think that's going to depend on the nursing home. Certainly you want to read those documents before you go into a nursing home or before you put a loved one in a nursing home. You want to look at those documents, see if there is an arbitration clause, and then you can bring it to the nursing home's attention and say, I don't want to put my loved one, for instance, in this nursing home if we have to sign this arbitration clause. And then the nursing home is going to tell you either, okay, we'll take it out, or they may say,
or
adios.
Or here's a referral for another nursing home.
Right.
Yeah.
See, and the problem with the Supreme Court upholding these arbitration clauses is that the industry catches wind of those decisions, and then they start to appear everywhere. Anyway, you're listening to Law Talk Live with Chris Dysart and Kelly Jackson. We'll be back. And welcome back. And if you have any questions or comments, please call us at 1-888-550-5877. That's 1-888-550-5877. Okay, Kelly, when we were talking before, we talked a little bit about whether somebody would have the right to try to change an arbitration agreement, for instance, in a nursing home contract. And I think the answer that I want to convey to people is you have every right to do that, and you should try to do that. That doesn't mean the nursing home is going to agree with it, but just because it's in writing, you should not be intimidated by it, and you should stand up for yourself.
I think that's a great idea. Our producer, James, over here, said, you know what, he was looking over a contract one time, and all he did was he just put a line through the things that he didn't want in the contract. Would that make it null and void?
It would be. If the other party signs it, it would. And, if the nursing home wants you to stay there, then they may agree with it. There's no law that says they have the right to do that. They only have the right to do that if you let them do it. Right. So, so I think it's definitely worth standing up for yourself and trying that.
And I'm sure that you have tried cases where families have, or anyone has signed these arbitration clauses and trying to get out of it. And
I have.
How difficult is that?
Well, let's just take the nursing home situation, for instance. It's going to depend upon who signed the agreement. For instance, if you're putting a loved one let's say you're putting your mom in a nursing home or something, and you sign the agreement, and then your mom gets, let's say she gets injured and she gets a bed sore or something that leads to sepsis, but she's still alive, then because unless you had like a power of attorney or something, your mother could still sue. The suit could still be brought in your mother's name. So it's going to depend on who brought it, who brings the suit, who signed the paperwork. Now, if, for instance, your mother signed it and she dies and you want to bring a lawsuit like a wrongful death suit, the fact that your mother signed it, that doesn't bind you.
Right.
The person that signs it also has to have the legal capacity to make a contract. And if they don't have the legal capacity to make a contract, then the contract or the arbitration clause cannot be enforced against you or them or whoever signed it. So let me just say a few more things about arbitration clauses, just to let you know what businesses really think about arbitration clauses. Now, in 75% of the cases where a business enters into an agreement with a consumer, they have arbitration clauses, or they want arbitration clauses in there. But when they enter into an agreement with another business where they may have to sue, guess what's not in there?
Not the arbitration
Yeah,
clause.
they don't put arbitration clauses in there. And you know why? Because they want to have a right to discovery. They want to have a right to a jury trial. They want to have a right to appeal the case. And you don't have a right, really, you don't have a right to appeal when there's an arbitration. The arbitrator makes a decision.
And that's it.
And it's basically it. You have like minimal rights to appeal. If the arbitrator doesn't follow the law, and arbitrators do not have to follow the law.
What do you mean they don't have to follow the law?
They can just basically, they don't have to follow the law. They can basically flip a coin and decide who's going to win. Seriously, they can. Hopefully they won't do that, but legally they can do that, and they don't have to write an opinion. So you may never know why they decided the case the way they did, and then it's like there's nothing you can do about it. And corporations know that, so when they enter into agreements with other corporations, they don't enter into arbitration clauses.
And an arbitrator is not a lawyer or anything, right?
Now, many arbitrators are lawyers, but they don't have to be lawyers to be an arbitrator. So they really, that kind of tells you a lot right there about, how much you should want to enter into an arbitration agreement with a company.
Right.
When you enter into a deal.
Boy, it just doesn't sound fair.
Okay, I'm just going to say a few more words about this campaign spending deal. Just because the U.S. Supreme Court issues a ruling that says you can have unlimited campaign finance in different forms, either the super PACs or to individual candidates if they turn out to do that in the McCutcheon case, there's still ways for citizens through their congressional representatives to overcome that. Like Congress has passed certain laws, for instance, with credit cards and things that they're trying to pass laws anyway, to say that you can't subject people to arbitration clauses or, so there's just certain ways you can do that. But anyway.
You need to read the fine print. I know that it's tedious, but many times people don't know what they're signing.
Right. So anyway, Kelly, we wanted to talk here for a few minutes about what's coming up next week. Next week, we're going to have a guest from the Missouri Department of Transportation, and she's going to be talking about ways to protect your teenage children when they start driving cars. And, I know
your children are young.
They are young, but, there's like two critical time periods for kids when they're growing up when they're most likely to get injured or killed, and that's between ages 1 and 4, and that's when they become a teenager at 16 or even 15, and they start to drive. Especially like the first 6 months of driving and the first year of driving. We're going to be talking about certain laws that Missouri has or Illinois has that are really good ideas anyway. And some of those ideas are to make sure that you drive with your teenager for like the first 6 months especially. And you want to drive with them under different circumstances, like during the day, during the night,
Yeah, and you need all that. It's interesting. I'm not sure exactly what the laws are for teen driving in Missouri, but when I was living in California, it was such that if you're at a certain age, you cannot ride in a car with other people, like 4 people in the car the same age. There were certain times of the evening that you could not drive. So it'd be interesting to talk to her about. There's so many things. Right. Teens are so distracted. Heck, adults are very distracted. So
yeah, I mean those are two key things you just talked about, because there's been a lot of research which shows if your teenager is in the car with another teenager, then they're far more subjected to like peer pressure and showing off and
on the radio, not paying attention, looking at their phone. So distracted.
Right. And the same thing with being out like past 10 o'clock at night or 11 o'clock at night. That's when a lot of these collisions occur, when these teenagers get killed. So, you really have to be careful about that stuff. And so we're going to go through the different laws that are in effect and also the different things that parents should do to try to protect their teenagers at that most critical time period because there's no guarantee that those bad things aren't going to happen.
Your twins are 4, right?
Yeah, I've got my twins are 4 and my daughter is 5.5.
Okay, so she has a good 10 years before she starts. Are you breaking out in a sweat already thinking about her driving?
Actually, not quite a sweat, but it's like a big concern. I guess I'm overprotective, but I just have seen so many cases, because I'm a personal injury lawyer, trial lawyer, and I've seen a lot of situations And I also, where kids have gotten killed, and and then growing up, I saw some of my friends get killed in car wrecks,
Yeah.
And it was almost always when there was other kids in the car and they were driving late at night. Sometimes there was alcohol was involved, and
yes. So I think it's a great idea. It'd be interesting to hear what she has to say as far as parents the first 6 months, heck, the first year driving with their teen in the mornings, afternoon, and the evenings.
Yeah, and it's just like it's not going to be an easy thing to do for a parent to do that. Obviously, your teenager is going to be wanting their independence, and it's going to be a struggle. But it's kind of like, well, is it worth it? I mean, is it worth it to drive with them for a while and drive with them under different circumstances? For instance, when it's raining out,
right?
Making sure that they're not out driving with a bunch of friends in the car. I mean, I think the answer clearly is yes, it is worth it, because once something goes wrong, it's too late.
Exactly. And I know we're almost out of time, but I know that at least California at one time, they were considering changing the driving age, the minimum age, to perhaps 18 instead of 16.
Yeah, and with kids, I'm all for it right now.
Yeah.
Because I remember when I was that age, I did really crazy stuff.
I did too.
Looking
back, I just don't know if some 16-year-olds are mature enough to be able to handle the rules of the road.
All right, Kelly. Well, thanks a lot. Hope you have a good rest of the weekend.
I hope you do too.
And you've been listening to Law Talk Live with Chris Dysart and Kelly Jackson.